Welcome to A Judge's Perspective on Personal Injury Damages. I'm Philip Vondra, co-chair of the Beverly Hills Bar Association's Personal Injury Law Section. I'm delighted to introduce today's speaker, the Honorable Margaret Oldendorf, retired. Judge Margaret Oldendorf is a mediator, arbitrator, and referee at ADR Services, Inc. She joined the panel in 2024 after nearly 20 years on the Los Angeles County Superior Court, where she spent the last 9 years presiding over civil trial and independent calendar courts. Known for her fairness, efficiency, and deep legal knowledge, Judge Oldendorf has earned numerous accolades, including Judicial Civility Award from ABOTA and Trial Judge of the Year from CACI. And now let's get started.
Bill, thank you very much, and good afternoon to everybody. Thank you very much for attending, whether you're going to be seeing this live or you're going to be listening to it later. This is a program on personal injury damages. We're going to go over both some black letter law and then also some strategy issues. Suzanne's going to run the PowerPoint for me, and so let's go ahead. And Suzanne, if you can go to the next slide. Let's just review some of the issues that I'm hoping to review with you guys today, and then hopefully have 5 or 10 minutes at the end for questions, which you'll put in the Q&A. We're going to talk about creating your approach. We're going to review some black letter law, especially in the area of economic and non-economic damages. Talk a little more then toward the end about strategy, and then the difference of dealing with damages issues in mediation and arbitration, if time permits. Next slide. Do the next slide there. This one isn't no specific content other than there you go. Your approach to damages, I would just want to first really encourage everyone to take the time, do the preparation at the beginning to identify unique issues in your case. Are non-economic damages going to really be a big driver in your case? Are the medical damages going to be a big issue, loss of earnings? Do you have someone who's got pre-existing conditions? Practically everybody does. And how these things affect the case. Let me just mention here, I'm going to be trying to look at this from both the plaintiff attorney perspective as well as the defense perspective. Some of this is a little bit more plaintiff oriented because, of course, we start with the black letter law on the plaintiff side, but all of these things I think apply equally to both the plaintiff side and the defense side. I have found personally as a lawyer and also as a judge that our CACI instructions are probably one of the best resources that you all have to review the black letter law in the area of damages. When I was on the bench, I did a lot of personal injury trials. I would, if I had the time, actually go through the entire 3900 series of CACI and just review them, get a sense of which ones may be applying to my case. They've also got just excellent resources in the use notes, directions for use, the authorities section. I spent a short period of time on the couple years on the Judicial Council Committee on Jury Instructions, Civil. And I found that very informative. One of the things that I learned as a participant on that committee is how hard that committee works to vet, to identify, and to articulate in the use notes the applicable law on a particular area. You can rely on that information. It's a fabulous resource. So I really, really want to commend you to that. Don't make your discovery necessarily real cookie cutter. Try to tailor it to the specific issues in your case. Don't be too shotgun. Just try to focus on what's going on. And then I think one really important thing you can do is get a little bit of scoop on your judge. Go to if you've got listserv available, if you've got other group blogs or resources available, ask around in your office, try to figure out, do you have somebody who's a micromanager? Do you have somebody who's pretty relaxed and easygoing? Either way, your judge, just remember, your judge is never going to want to commit reversible error on anything. And so you want to educate your judge if you think it's an area that they may not be aware of. This is my own opinion, but having been on the other side of it as a judge, just because you might be able to get away with maybe a borderline or a risky argument doesn't necessarily mean that you want to go ahead and do it. Because if your judge has made a mistake and it goes up on appeal, it could be coming right back down. And of course, that doesn't do your client any good. So I think that that kind of investigation is very helpful. We can go to the next slide, Suzanne. I just told Suzanne and Phil when we were prepping, let's see, we've got a slide that says, where's the blackboard? Yeah, that's what damages look like to a judge sometimes when we're trying to learn about your case. So, okay, thanks. Next slide. Just a little background. We're just going to try and go through this hopefully pretty quickly. In the damages area, we all are aware of the collateral source rule. There's no offset entitled by the defense for compensation that a plaintiff may receive from an independent source. That's the general rule. There are some exceptions. This would include payments from the plaintiff's insurer, even maybe gratuitous payments by employer or family, other sources. There are some exceptions that may apply. It's going to be unique to your case. Subrogation cases. Those of you who do med mal, you're aware of Civil Code section, I think it's 33.2, which may allow information on payments. This Stokes versus Mushinski case, a fairly recent case out of the 2nd District involving one of our LA Superior Court judges at trial. It's a case that's interesting because it discusses what happens during trial when information relating to collateral sources, Medicare, Social Security eligibility, insurance through Kaiser. The gist of the case is that passing references to this information in and of itself is not going to violate the collateral source rule and won't be prejudicial. In fact, as we may discuss a little bit later on here, it could actually be information that's relevant to the jury determining the reasonable value of a particular service. We can go to the next slide now. Past meds, basically 4 elements to the general rule. A plaintiff is entitled to get reasonable expenses for medical services that have been actually rendered. They do have to be reasonably necessary. And of course, it has to be something that was causally connected, caused by the particular accident or incident. CACI 3903A is your basic rule on that. Typically, most of this is going to require you to present it through or challenge it from the defense side through competent expert testimony. Your plaintiff probably can testify about a specific service they received. Yes, my broken arm was set, or something like that. But everything else really is going to wind up having to come through expert testimony. Next slide. So what's a reasonable medical expense? Here we get into the Howell case and its progeny. Reasonable payments for past meds cannot exceed the amount that was either actually paid or incurred. So, Howell, General rule, a plaintiff may recover the lesser of the amount paid or incurred and the reasonable value of that service. Next slide. What does that mean? If the plaintiff has medical insurance, then if the provider has billed for that service, gotten paid, and there's some kind of a discount, and the provider, the doctor, the hospital, whatever, has accepted that payment, even if arguably the reasonable value might be more than that, you can't recover any more than the actual payment because the plaintiff can't recover any more than the actual loss. So that's what we mean when we talk about reasonable value less than the ordinary rate. These amounts are often easy to identify. And many of you are aware, if you practice in this area, we refer to these as the so-called Howell numbers. Frequently, counsel reach stipulations on these numbers, and your judge is going to want to kind of try to get you to do that so you don't have a big fight during trial getting bogged down on information that's probably pretty easy to determine. Harder area, if an expense hasn't yet been paid, then you've got to get into the detail a little bit more. You've got to determine whether the service represented the reasonable value. What was billed is the reasonable value. And this is the case whether there was insurance or not. In these cases, Bermudez, Pebbly, you're all probably pretty familiar with it. This is more of a battleground every year in my experience because we see more and more every year treatment on so-called medical liens. People who voluntarily choose not to go through their medical insurance and instead seek treatment on a lien for various reasons. So this is an area where you're going to see some case law developing, I think, and it's important for you to review it and kind of be up on it. We can go to the next slide. Future meds, basically a three-part test. Again, you can get the reasonable value of medical service, that the plaintiff is reasonably certain is going to be necessary in the future. And again, it's got to be attributable to the accident. One of the best cases dealing with future meds is this Kornbaum case. And again, we're looking at CACI 3903A. We can go to the next slide. Here's kind of an evidentiary way to look at some of these issues. If I were a plaintiff's lawyer or a defense lawyer, stay away from using the term medical insurance per se. The focus is on what's the reasonable value of a service. The cases over the last few years, including the Bermudez case, which I cited on one of the prior pages, makes it clearer every year this develops. The courts are going to be willing to permit what they term a quote unquote wide-ranging inquiry into what's a reasonable service. If you look at CACI 3903A, it talks about the cost of a service. And so this is the inquiry that the court is going to allow the parties to engage in so the jury can evaluate. Things like patient payment, a cash payment for a service, although that kind of implicates the absence of insurance, evidence that a patient personally paid for a service, depending on the circumstances of your case, might be allowable and relevant by the judge. Some cases, especially if you've got life care planners and they're looking at future meds, your life care planner may talk about the market value of a service. There are some cases that deal with testimony concerning the quote unquote exchange value of a service. These inquiries may be permissible. Even a life care planner who uses as a benchmark Medicare reimbursement rates, even if the individual isn't Medicare eligible, that might be relevant. This case that I've got here on this slide, Oddish versus Macias, is a recent case out of the 4th District. It involved testimony by the plaintiff's life care planner on future meds. And this was the life care planner for the plaintiff, but on cross, she was asked some questions about future meds, and there was some testimony about the plaintiff's future eligibility for Medicare. And how that might relate to the value of a particular service. The court found that it was not a violation of the collateral source rule to have that testimony, that it was relevant to reasonable value. So again, you can see this area is very, very fluid right now. It's fertile ground. It's something that may be important in your cases. We talked a little bit about medical service on a lien basis. Evidence concerning lien treatment may be permissible. I allowed it in many cases, particularly if the medical provider, the doctor, was on the stand and on cross-examination, it was developed that he or she provided that treatment on a lien basis. My feeling was that it can be relevant to bias. It may actually even be relevant to reasonable value. It could also be relevant to what the plaintiff incurred. For example, it may be that it's appropriate to ask the treater, do you billed for that, but do you actually expect to be paid for that? Those may be fair game, those questions. In the area of lien treatment, you may be bumping up against some attorney-client issues. The Kadir case, I just realized when I proofed this morning, I'm sorry, there's an extra U in that name. It's QAA. Kadir versus Figueroa 2021 case, one of our judges in LA dealt with that case. The Court of Appeal ruled that whether or not an attorney referred a patient, a plaintiff, to a so-called lien physician was relevant to bias, also maybe reasonable value. This is an area that can be a little bit dicey because of attorney-client communication. Is the date the attorney actually was retained in comparison to when that plaintiff went to that lien provider doctor? Is that relevant? Maybe. As a judge, I think my perspective is the actual date an attorney was retained is not an attorney-client communication. It's probably just a fact as opposed to a communicative act. But I've had that discussion with lawyers on cases before. These are areas for you to be sensitive to and to prepare for. They may come up in your motions in limine. Sometimes they come up right during trial, so you want to be ready for them. Okay, Suzanne, we can go to the next slide. Past and future lost earnings. This sometimes is a big issue in personal injury cases. Sometimes it's not. Your CACI instruction 3903C deals with lost earnings as opposed to lost earning capacity. We'll get to that in just a minute. But the focus in 3903C is what is the plaintiff lost to date and what are they reasonably certain to lose in the future. We've now got our instruction 3906 that makes it clear, if it wasn't already, that criteria such as race, gender, ethnicity cannot be used in any way, shape, or form as a basis for any reduction in someone's lost earnings. We can go to the next slide. Lost earning capacity. So slightly different, right? This is 3903D. So it's the difference in what your capacity was before and what it is after. A traffic collision. The plaintiff is a professional violin player. Serious injury to neck and arm. A promising violinist, not going to be able to have that vocation after the accident. So what's the difference? And maybe can be a teacher now, but can't be a professional musician. What's the difference between those two things? This is a decision for the fact finder, the jury, or the judge. This Lewis versus Ukraine case makes it clear that you don't necessarily need expert testimony in this area. It may be that the plaintiff can testify. It may be that you've got some comparative evidence, proof of the plaintiff's prior earnings, pre-incident versus post-accident might be available as a comparison. Okay, we can go to the next slide. Then one of the other big areas, of course, is non-economic damages. And this is set forth in CACI 3905A. As you all know who practice in this area, I remember saying it to juries during voir dire when the issue of damages came up in questioning of a jury. And of course, I would read this instruction. There is no fixed standard for determining the amount of non-economic damages. The jury is told that they must review the evidence and use their common sense. The bottom line is the test. What is a plaintiff reasonably certain to suffer? In 3905A, there are various enumerations of examples. Emotional distress, humiliation, pain, suffering, the loss of enjoyment of life. And you want to tailor that jury instruction to the specific facts of your case. Remove the inapplicable examples. You run the risk of confusing the jury. You could alienate the jury if you included things that just clearly don't apply in your case, and keep your focus on those things that are specifically created by the particular facts of your case. One interesting area that I saw, and some of you may have seen, is whether or not you would be allowed to include as an item of non-economic damage a diminishment or a loss in life expectancy. We have our instructions and, of course, the actuarial tables on life expectancy. And in many cases, those are specifically read to the jury. But this is a little bit different. Are you entitled to argue that you suffer a non-economic damage, a form of emotional distress, basically, if you've now are aware that your life expectancy has been shortened. I don't know the answer to this. So far, this has not been something that has been included in the CACI instruction on non-economic damages. That probably tells you a little bit about where the committee is in terms of its comfort level about including it. And so it may be something that you might, depending again on the facts of your case, have an argument with your particular trial judge on. So I raise it as maybe a potential developing area on non-economic damages. Okay, let's go to the next slide. Let's talk now about strategy. Let me emphasize, these are my opinions as a retired judge, having done a lot of personal injury cases. I don't speak for the court, for EDR, any other entity. But these are my views based on what I saw juries doing. Many of you may disagree with some of these thoughts, and you may be receiving some training that might challenge some of these perspectives. It's all fair. Take all of it, find out what works for you based on your personal experience, your personality, your comfort level, and then, of course, do what you're comfortable with. I think two of the most important things you can do as an attorney in a personal injury case, whether you're the defense or the plaintiff, try to establish that trust, whether it's your fact finder is the jury or the judge or both. There's just no replacement for that. Juries are sophisticated, this is my view, and they're also very cynical. And they take everything with a pretty healthy grain of salt. And if you're way, way, way over the top and really, really kind of out there from the beginning, they are going to dial it back and not place a lot of trust in you. And so you want to build your ask, I guess, with building blocks slowly. And you don't want to overpromise things, especially at the beginning. You don't want to improperly inflate your case too much with flowery language, huge numbers, outrageous claims. They will start to tune you out. And when you lose them, it's really hard to get them back. So I think if I would have any kind of advice to someone going into practicing in the personal injury area, that would probably be my strongest admonishment. During the voir dire process, which, as we know, is your first time to have contact with the jury, there are some challenges in dealing with damages. Probably one of the biggest ones is whether or not you, as a plaintiff's lawyer, are going to try to introduce specific dollar amounts to the jury about what you think the evidence is going to show and how your client suffered X thousands, tens of thousands, hundreds of thousands, millions of dollars in damage. My approach in this area as a judge was I would not allow attorneys to mention specific dollar figures, especially dealing with non-economic damage, but they would be permitted to indicate to the jury that they expected the evidence to show that their client incurred substantial, significant, extreme, pick your descriptor, amounts of damage. I thought that was fair in order for attorneys to figure out whether or not that particular juror or that veneer group of jurors are going to be open-minded about damages. I also encouraged attorneys when I would start a personal injury trial to be very thoughtful about how they raised the issue of damages during voir dire. I would sometimes give a little bit of a spiel before the attorneys started questioning jurors and explain to the jury that if you're selected to be on this jury, you're going to be asked to do kind of two basic things. You're going to be asked to determine liability. Was there negligence in this case? Is the defendant responsible for the claimed injuries? And then if there's liability, you're going to be asked to determine what amount of damages, if any, is appropriate. And then I talk a little bit about damages and say within damages, they're typically going to be both economic damages, which are sometimes a little easier to determine, like medical bills. And then there may be maybe lost earnings. Then there may be non-economic damages. And then I would talk about the general standard on non-economic. And I would try to describe this kind of universe to the jury and then say something to them like, does everybody generally understand those concepts that I've just described for you? And usually everybody, kind of nods their head. And then you've introduced the concept, and then the lawyers can go in voir dire and kind of build on that. In comparison, I've seen problems develop where a lawyer, it could be either a plaintiff's attorney or a defense attorney, would get up and they would say, so how does everybody feel about pain and suffering? And frequently jurors, they're not quite sure what you're asking them, but then somebody on the jury says, oh, well, I don't believe in that. And then you get in this weird kind of dialogue with the jury about trying to explain that whether or not they award pain and suffering damages, which is a subset of non-economic damages, we know, is going to depend on the evidence in the case. And if you've got some constraints on talking about specific items of evidence in the case, and then you've got yourself talking to this juror about why it would be important to be open-minded, you've kind of backed yourself a little bit into a corner. So voir dire is really kind of critical, I think, on how you introduce these concepts, how far you go. I think that there's a bit of a red flag if you try to ask for specific dollar figures or mention them in voir dire, because your judge is going to be sensitive to that. You may elicit an objection. It may be something that gets dealt with in a motion in limine, because the defense side is going to want to have you avoid what we call anchoring. So be sensitive in this area, really give it some thought. Get your jury generally willing to stay open-minded about the evidence in your case, but do question enough so that you can weed out those people who are going to be resistant to listening to the evidence, I guess. And that's from the plaintiff perspective, and from the defense perspective. Of course, you want to kind of examine in that area as well with your goals in mind. Then, of course, after you've done that work and you've got your jury, you get into your opening statement. And how do you handle damages here? Again, the extent to which you are going to be able to identify and say that you think that the evidence is going to show that your client experienced, X amount in medical bills, is going to depend a little bit on the comfort level of your judge. If you have questions, I always advocate for people asking ahead of time and trying to work these things out so that you don't have last minute surprises or objections. Again, with non-economic damages, I think you're going to want to stay more broad brush. If you've got a case where causation is a really big issue, for example, you've got a client who has a significant pre-existing condition, and there are so many cases like this. Again, my viewpoint, try to deal with it up front. Don't try to hope that it won't develop and you won't have to deal with it that much. You're going to have to probably at some point confront the concept of pre-existing condition. Your medical experts are going to have to deal with it. Your other experts may have to deal with it. Look at CACI 3927 and 3928. Those are the instructions on 3927 is pre-existing condition, aggravation of pre-existing condition. 3928 is the so-called eggshell plaintiff instruction. Those may come into play in your case. And so you're going to, if you're the plaintiff and there is a pre-existing condition, you're very likely going to be able to get that 3927 instruction, possibly 3928. Sometimes the defense wants 3928. And think through how, for example, a pre-existing back injury is going to impact a rear end accident and a back injury on the new case that you're handling. You're going to have your doctors be willing to deal with this. Getting it out front, you don't have to make a huge big deal out of it up front, but being able to acknowledge it, I think it just helps you once again build that trust with the jury so they don't think you're trying to avoid something. Something that I have felt is really important is this concept of keeping an eye on the jury. I know you're doing a million different things, but some of the best personal injury lawyers I've seen, they don't make it super obvious, but they're always watching the jury because you'll get reactions from your jury and you'll know if something's landing with a thud or they're really into it with you. And if you've just got too much going on, get somebody else on your team, even if they're sitting in the audience, watching that jury, see how they're reacting to what you're saying. Which juror is reacting to what? And it's going to help you understand whether your message is resonating or whether you're not, being received well. I think it's really, really critical. One other thing in this area where you're talking about voir dire opening, be thoughtful and careful about your word choices. The way that you present your case is a huge part of the chances of success. And this, of course, plays into how critical preparation can be. Okay, we can go to the next slide, Suzanne. Here's another, I think, important concept. As the lawyer, don't get in the way of your evidence. Let it come from the witness. This is especially important as the plaintiff's lawyer, but it's also very important as the defense lawyer if you're cross-examining or you're questioning your own witnesses. Avoid, and here is where preparation, witness prep, planning is so incredibly important. Avoid long, convoluted questions where all the witness has to do, a leading question, where all the witness has to do is say, yes, that's right. Not only will you probably elicit an objection, or if it was somebody like me, if it's really bad, I might actually interrupt and say, please stop doing that. You don't really learn anything from your witness that way. The jury doesn't learn anything. So you want to prep your witness, tell that witness where you're going, tell them what you're trying to accomplish. Don't have your witness be, over the top, exaggerated, flowery. I always feel like low key is always better, but have them be descriptive. They may be shy, they may be nervous, certainly. You may be able to lead the witness a little bit if, as they get into things, they're having difficulty maybe articulating what they're trying to say. That's okay. In fact, I think that's very human, and that's actually, you can kind of endear the witness to the jury a little bit. But set up a question and let the witness answer in their own words. I think you'll get better evidence that way. Tailor the questioning to the case. By this, I guess I mean you want to build your particular story. I think of a case that I had with a really good plaintiff's attorney who had a young plaintiff who had suffered some severe injuries. And the attorney broke the description basically down into pieces. And although the medical treatment had pretty much been over, it was really very compelling that this individual had gone through so many different treatments, surgeries, time in the hospital, rehab, and rather than kind of lump it all together, he kind of broke it down, and the witness talked about every stage of it, not repeating what she was saying, but going over it. And it really kind of built, to sort of a crescendo. If you have a case like that, work on breaking it down a little bit, focusing your questions. Again, this is an area where your witness prep is just going to be so important. Or if you're on the defense side and you're doing cross-examination of the plaintiff, prep those cross-examination questions to get the exact answer, of course, that you want to get, that you think the evidence is gonna give you. Let's go to the next slide. Closing argument. I think that it is very important, again, for juror trust, enhancing your outcome. Don't skip an issue. Go over every issue that's important. Now, your jury can only retain so much information. You want to be, judicious about how you do it. But for every important point, hit that point, be able to explain why it should be the way that you're arguing, why that item of damage should be awarded. If there is, for example, a big pre-existing condition issue and you're worried about it as a plaintiff's attorney, don't skip the issue. Deal with it. Even if maybe, if there's a particular issue, even if you feel like it's a red herring, you can say something like that. This is a diversion, this is a red herring, and I really don't think that it's something you need to be concerned with, and here's why. If you've got some kind of a losing issue, you know what? Consider just conceding on it. Don't try to make, don't twist yourself into knots. Try to explain something that is just not going to come out right, because you'll lose credibility with your jury if you try to do that. Have a backup plan. Okay, you know what? I'm going to concede that issue. It turned out that my client, didn't say that he hit his head when he was in the emergency room. You're right. It doesn't show up in the medical records. However, I don't think that that's an issue, and it shouldn't be something you should concern yourself with, because when he went and he saw the neurologist a week later, this is what was developed. Something like that. Be willing to, be agile. Be willing to deal with it. And rather than try and kind of take an extreme or an outrageous position, I really, really feel that being disrespectful to the other side, to the attorney, to the witness, to the party, juries hate it. Judges certainly hate it. Really avoid it. There are civil, respectful, appropriate ways to respond to somebody's argument, to put somebody in their place, so to speak. Find those ways. Don't take a cheap shot. Makes you feel good for about 2 seconds, but it usually backfires. Don't be overly extreme in your demeanor, in your presentation. I had a lawyer one time in closing get in front of the jury, right in front of the box. I didn't know he was going to do it, and he fell over, and he was trying to give as an example what happened to his client. Well, it was just completely ineffective, and it was a little embarrassing for him. It wound up, a lot of the jurors laughed. They were very turned off. And so, be very careful when you do things like that. Know exactly kind of how you game out how it's going to look before you decide to do something dramatic in the courtroom. It's always great to give your jury alternatives. If you're the plaintiff's attorney, you're asking for a certain amount of damages. Consider giving them a range. Consider giving them different ways to calculate, for example, non-economic damages, rather than just giving them a number. Letting them be involved in the process is empowering to the jury. It shows respect for the jury. And it becomes a little bit more of a team effort, if you will, between the lawyer and the jury. And so I think that it's very, very helpful if you do something like that. You can tell my last point, this is sort of my perspective. Less is frequently more. And I think sometimes you get more out of your jury when you downplay certain things. And then emphasize the really important stuff. Save your, your energy and your fire for those really important things. Okay, Suzanne, we can go to the next slide. We've got just a little time before questions to talk about the difference in mediation and arbitration. You've obviously got a different audience. You're not going to be dealing with a jury. You're going to be dealing with a neutral who's got some experience in your area, hopefully. You're going to have people on the other side who are very experienced, hopefully. You can be a lot more kind of cut to the chase, a little more realistic. If you're trying to settle a case in mediation and you're either arguing for a high number on settlement as the plaintiff or a lower number as defense, have facts at hand. If it's one thing that I've learned doing this now for about a year is mediation is very interesting. It's really dynamic. And it can be hard sometimes to figure out what might impact the other side in a particular back and forth. And so there may be times during a mediation where you want to throw out an important piece of information that maybe you haven't felt like the mediator, the other side has had time to focus on yet. You got to know that stuff. You've got to have that in your brain. So you need to know about your case. You've got to have these facts available, and you need to be able to be willing to provide it to the other side. Give your mediator tools, ammunition, ideas. Judge, this may be something that it might be a good idea to raise at this stage of things. Make sure they know that I've got, this person has a really significant social media presence, and we've looked at that stuff, and it could affect how your party comes across. So think about these things. Think about how to use them during your mediation. In your arbitration, you're going to have one arbitrator or three arbitrators. You're not going to be able to go nuclear really in an arbitration. If you're trying to, you're going to have to be able to explain it. Again, you've got to give that detail and methodically lay that out for your arbitrator. And again, I think that this is another area where being more low-key, less kind of out in the stratosphere is more likely to establish that trust, which goes a long way toward accomplishing what your goals are. So that is kind of my 2 cents on, we can go to the next slide, on damages. I wanted to just highlight a few resources that I think are very, very helpful. Of course, I've already mentioned the CACI instructions. A couple of the rudder guidebooks are really, really good on personal injury and personal injury damages. The PI rudder guide, the civil trials and evidence. Another book that I love I don't really use it in mediation so much, but I used it a lot on the bench, is this Simon's Evidence Manual. I think there's a 2024 edition, it might even be 25 out now. This is a really good evidence book, and it's also got good case discussions, so you might want to look at that as well. And next slide. Thank you, everybody, so much. I hope you have found this helpful. Please call me, and if you want to run an issue by me, if you have an arbitration with me, please don't call me. That would be an ex parte communication. But if you want to talk about something, I'm happy to try to help in any way that I can. I think we've got a couple of questions. So I'm going to go down here, Suzanne, and look at this. Let's see. Here's a question. If you did not allow specific numbers by a plaintiff rate damages, did you allow the defense to say zero or nothing? That's a great question. I think if the plaintiff is going to say something like, I think there's going to be a substantial, you're going to see the evidence is going to show that there's going to be you're going to be compelled to give a substantial award in this case. And I think it's going to be okay to allow the defense to say, I think after all the evidence comes in, you're going to conclude that the award is going to be nothing because there's no liability here. So I guess the answer is yes, I think it might be possible to allow the defense to do that. I've been asked, who are some of your favorite plaintiff attorneys in trial? I'm gonna take the fifth on that one. I will say this, if you're getting ready to go to trial and you haven't maybe had a trial in a while or a lot of trial experience, try to find out what's going on. And if you've got the time, try to make the time. Especially if it's in front of the judge you're going to have. Go down, observe, see what's going on. Okay, we've got a couple more here. What techniques have you seen be successful for framing lien/attorney coordinated treatment to the jury for plaintiff? So so let's say that someone went to, let's say that somebody has decided to go to an attorney, excuse me, to a doctor, and the treatment is on a lien, and let's say that it possibly comes into evidence that that plaintiff had Medicare or was a Kaiser patient or something like that, and they didn't go to a Kaiser doctor. I've seen plaintiff's attorneys ask, why did you go to X doctor? Well, I felt, it has to be genuine, but I felt that that person had a lot of experience with the particular kind of fracture that I had suffered. And I thought that it would be wise for me to get that care. I wanted the best care that I could get. Why did you go to the doctor that your lawyer referred you to, if that came out? I've seen people say, I didn't know what to do. I needed help, and I needed help. I consulted a lawyer, and, they helped me through the process, things like that. I think those are kind of genuine answers. And then the jury decides what they're going to do with the lien treatment issue. Let's see. Is there a formula for pain and suffering that's most credible in your view? or more credible than not? Per diem, per hour? How was it postured? I think this is a great question. You know, this is where alternatives help a lot. Giving people alternatives. Maybe you want to look at it on a per diem, for example, X. Maybe you want to, maybe you're an hourly employee and it's of value to you to look at it this way. I'm going to suggest to you that you should consider, for the difficulty that my client has experienced, an award of X. Just giving them this is my own opinion, just giving a jury like a per diem or an hourly rate is kind of artificial. And if that's the only thing that you do, I don't know. I don't know how helpful that is for juries. I like it when I thought it was successful, rather, when attorneys gave the jury alternatives. Okay, let's see. I think we might have one last question and then that's it. I'm pre-reading this. Wow. In a pregnancy discrimination case where the plaintiff was trying to get pregnant, and that ability to get pregnant is arguably diminished by the stress of the discriminatory conduct, is it too speculative to ask for non-economic damages related to diminished fertility? Wow. So here's a good judge answer. I think the answer is it depends. Because if you're probably going to have an expert. It's probably going to be a gynecologist, right? Maybe a fertility expert. And that person can testify that stress is a huge factor, or a factor, an important, a significant factor in someone's ability to get pregnant, then you've got the support for making that kind of an argument. You may need to tie it into some expert testimony, however, and that's where if you can't do that, then your judge might be a little bit concerned about that being too speculative. The alternative to that, you just talk broadly about the kind of stress that the client was under and how life changed, things got difficult. Maybe that's a way to do it. Okay, you guys, I think that's all the questions. And thank you so very much. And I wish everybody the very best of luck. I miss jury trials, but mediations are fun too. And call if you want to talk. Thanks. Bye.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.